Thank you, and may it please the court. As mentioned, my name is Matthew Cease, and I represent Scott Clark and Real Tuners in this matter. Today, we ask that this court reverse the district court, and we do that for three primary reasons. First, we believe that it was improper for the district court to read into jury instructions several facts deemed admitted. Secondly, we ask that the court reverse the district court in precluding Mr. Clark from certain cross-examination of Mr. Hoffman regarding Mr. Hoffman's reputation and the reputation of his company. And third, we ask that the court reverse on the basis that the jury award in this case was flagrantly excessive. Starting with the first issue, as the court is, as I'm sure aware, as a sanction for violation of a consent order in this case, the district court ultimately struck Mr. Clark's answer and counterclaims and deemed the petition of the plaintiff to be admitted. And then the court specifically said that the trial in this matter was to be a damages-only trial. And we have issues with that as outlined in our briefs, but I want to focus on the act of the district court allowing 100 paragraphs of facts deemed admitted to be read to the jury. We have, as we outlined in our brief, significant problems with 12 of those. Those 12 all involve matters that were not within the purview of the jury, or specifically instructed the jury that they must do things like award punitive damages and find that Mr. Clark acted in bad faith. I think that was referenced 3 or 4 times. In fact, one time the instructions said that he must that he was acting in the utmost bad faith.
Did your client make any objection to any of those facts?
They made a general objection to that instruction in its entirety, and that's what we have in the record through the trial counsel. And it was a general objection for that. They did not specifically outline the ones that I'm outlining, but I tend to agree that all of the facts are problematic once the court makes the decision that that this is going to be a damages-only trial. And when that decision is made, the liability aspect of this is very minimal and frankly irrelevant. Go ahead, Judge.
Counsel, with respect to your last comment that the facts are frankly irrelevant, I wonder if you could address the appellee's argument that then those facts would not be prejudicial.
Sure, and if we look at the law, and we reference it in our reply brief, that we need to eliminate an unnecessary and duplicative aspects. But when you look at them in a whole, and the jury instructions are providing those 12 specifically that we reference, that's where the problem really lies. And I appreciate the appellee's arguments that, well, the other areas of the jury instructions in the court and during closing argument, the jury was all told that that it's their decision to make the damages, but we have this specific instruction that's clearly inconsistent with that, where it says that damages are almost impossible to prove in these types of cases, that punitive damages should be awarded, that Mr. Clark should have attorney's fees against him, that the equities are in Hoffman and DIY's favor. All of those facts are significantly problematic. And also, as we reference in our briefs and the authorities that we cited, including that law review article by Mr. McNulty, the problem is with these types of cases is that they cannot be tried on the defamatory statements alone. And when you look at the facts deemed admitted and the facts as they were presented in this trial, that's what this trial really boiled down to, was a trial on the facts themselves and less so on the specific damages, which was supposedly the point of this trial. This was supposed to be a damages only trial. And when we look at the day and a half or 2 days of testimony that came in this case, it really came down to almost entirely about the defamatory statements and the actions of Mr. Clark, and even some flavor of his actions during the litigation itself. And that leads.
But you can't really get to damages without knowing that background, can you? As a fact finder,
I think that there is certainly some overlap, Judge Greer, but I don't think it can't outweigh the damages evidence that needs to be presented. And in this case, there just really wasn't any damages evidence. The extent of it, at least when we start talking about numbers, was just Mr. Hoffman saying that I think DIY has been injured $4.5 million. And he said that was based on his analysis of a loss of revenue and not growth, and not accurate growth that he had been experiencing over at least 1 year prior. And that's a problem. And as we outlined, the problem is that he's not seeking lost profits. It was just revenue. And so that's not factoring in things like cost of goods sold and the cost that it takes to generate that. And he never testified once that there was any lost profits or that significant of lost profits. And we run into the same issue when we talk about the personal damages as well. Go ahead, Judge Greer.
Well, I was just going to say that sounds like a good cross-examination.
And they attempted to do some of that cross-examination. And that's where I think the cross-examination ended, is that there was no actual lost profit. So that part of cross-examination certainly came. And then I want to go to my middle argument, I guess, and talk about the exclusion of cross-examination that was done or attempted to be done by Mr. Clark's trial counsel. Mr. Clark's trial counsel specifically tried to get into the reputation of and character of both the company, DIY, and Mr. Hoffman, but was shut down pretty quickly by the district court in both of those instances. For Mr. Hoffman personally, he was asked whether or not he's ever been charged with a felony. And that's certainly a relevant piece of evidence that is one of the central issues in a defamation case when we are talking about reputational damages of an individual.
Counsel, as I recall the Appellee's brief, there is an indication that issue really goes to the ruling on the motion in limine. Why wasn't that ruling dispositive in your view?
Well, I think motions in limine are always, in my view, temporary in nature, and the real issue comes up when it happens in trial. And the district court could have reversed themselves when that was presented to the district court, when they actually heard that testimony. Additionally, it's not an issue, especially when we start looking at the cross-examination that attempted to be done regarding DIY. The appellee and Mr. Hoffman argued that this was all going to the truth of those defamatory statements, but that's not really the case. Again, just like there's that overlap when we talk about damages, it applies both when we are the defendant and the plaintiff. And so the reputation and whether or not DIY had admissions in the public forum regarding specific product or potential product failures absolutely goes to the issue of whether or not it was Mr. Clark's statements that caused any potential reputational damage or lost profits, and not the specific truth of what Mr. Clark was saying. And so those individual questions all should have been admitted. I see my time's about up, and I reserve the rest for rebuttal. Thank you.
Thank you, Mr. Cease. We are ready for the appellee's argument. I understand, Mr. Katz, that you will be presenting that argument.
Well, thank you. May it please the court. The questions asked of Mr. Cease are truly excellent questions. The reason that Mr. Clark found himself in the predicament and the defendants found themselves in the predicament they were in was one of their doing. I noticed that there was no argument as to the striking of the counterclaims, which I thought was a large part of the defense. But in any event, I won't spend too much time on that other than to say this was a situation of their own making, the defendants, that is. This was not a jury instruction, these admitted facts. These were things that were taken from the complaint that were deemed admitted by a failure to answer. We submitted a list of approximately 100 facts that were to be deemed admitted as a consequence of the default. There was no objection made to any of them. And as was said already, when trial came around in the pretrial proceedings, there was a general objection to the facts being read as a whole, but certainly no objection to any of them.
So your position is that came too late?
It came too late, really not at all until appeal anyway. So yes. And as far as having to go through some of those facts, with all due respect, it's not practical to sit a jury down and jump into numbers without providing some factual background. And our belief is all of the testimony focused on the damages that were suffered, how they were suffered, why they were suffered. And that was the focus of the trial. In fact, the trial was shortened considerably due to the nature of those things. So these admissions at trial were just that, to the extent they...
Excuse me, with respect to the damage question, I wonder if you could address the civil extortion damages and what testimony in the record specifically went to the damage award of $250,000 there.
Sure, I'd be happy to. First of all, I should say there is absolutely zero argument that civil extortion damages were duplicative prior to this appeal. That is a new argument raised on appeal. There's nothing in the record to suggest it came prior to appeal. So therefore, we contend it's an improper argument. In any event, the jury was played a tape that is in evidence, a recording of Mr. Clark saying to Mr. Hoffman, I want you to pay me a severance, and if you don't do that, I'm going to make a stink on the internet. Translation, I'm going to cause problems for your business on the internet. There was testimony that Mr. Clark had offered to do that for Mr. Hoffman about another business, to which Mr. Hoffman declined. There was testimony that Mr. Clark knew how to hurt a business via such social media campaigns or smears. And then the evidence was that Mr. Clark made good on his threat after Mr. Hoffman refused to pay him a severance, and he did exactly that. And he did a very, very good job at hurting Mr. Hoffman's business. And both trial judges in various orders agreed that he knew what he was doing. He did it intentionally, and he was quite skilled at it. So we left it to the jury's determination based on the testimony as to the damages Hoffman and Hoffman Innovations suffered to calculate a figure of at least $250,000 due to the damage that he caused. If I may, to the extent that these, we briefed this issue to touch on some of the highlights, to the extent that these admissions were somehow problematic, Iowa law is clear that admissions can be really anything. They can be conclusory, and they can certainly go to the jury, and it's incumbent upon the party that the admission is to be used against to say, I object, that's improper. It could have been used or raised in response to our list of admissions. It could have been raised in the motion in limine phase, but it wasn't, other than, again, generally saying Clark objects to the use as a whole. So there were a lot of opportunities to raise these issues beforehand, and of course our brief sets forth the reasons why we don't believe it was in any way prejudicial or harmful. The jury was advised by me, by Clark's counsel, by the trial judge, by the instructions, that it's their function to decide whether or not to award punitive damages. And to the extent it was something about injunctive relief, again, that was something that was incumbent upon the defendants to raise as a problem, but any effect in our mind would have been de minimis. Forgive me, I'm just looking at the timer and it looks like I have 5 minutes.
Yeah. So can you address on this record the argument that these damages were excessive, that this 11 million is too hefty a number for these facts?
Sure. And really any figure can be called too hefty a number. The nature of libel per se, when you affect someone's reputation, affect their business reputation, there's a reason why the law, as the court is aware, there's a reason why the law assumes there are damages, because that's a really serious thing to do. In some respects, the points of this case are circular in that there's much to do in appellant's brief about striking of the pleadings. Well, the striking of the pleadings goes to a consent order that the trial judge entered that said, nobody say anything bad about each other during this case. And there were a few reasons for that. One of the reasons was the unique nature of the evidence in this case. Facebook data, briefly, if the court's not aware, someone has a Facebook account, they can post on their own name. A friend can post there. They can go under aliases like Mr. Clark did. You can reach a huge number of people. You can post on industry websites. And that's, all of those things is exactly what Mr. Clark did in this case, both defendants. And so the damages, the people, the audience reached by these false statements that my client's product started a fire, burn people, that my clients knowingly sold products out of greed. After my clients, the evidence is, as the trial judge noted in her ruling on the post-trial motions, my client prided himself on doing everything that's right. That was the testimony of forming a business based on Christian principles and serving the customer and doing things that were right. And his reputation was destroyed. His business partners were targeted and told that business with them would stop if they didn't abandon my client. It really was an all-out assault to an amazing degree. The trial judges in this case, and the lawyers too, if I may, have never seen anything quite like this. Mr. Clark was amazingly successful at what he did in targeting an incredibly huge audience and really causing a lot of damage. So in addition to the pieces of evidence, which the court can certainly look at its own, that Mr. Hoffman spent weeks, months combating these false statements, Mr. Clark suggested that Hoffman would receive products in the mail that the customer said were defective. And according to Clark, Mr. Hoffman would just put those back in the mail without running a test and send them back. So my clients have customers, prospective customers, business partners, people in the industry reading this. They're getting bombarded with these allegations and questions, and people returning products in fear that my clients are selling fire-prone issues. When my client started his business, he did so in a spare bedroom. He was the only one that offered this sort of product. That's the evidence in this case. And he had incredible growth momentum because he testified that he did things the right way. And what this campaign against him did was it almost destroyed his business. And it required him to cease any sort of growth initiative, killed the momentum that was going upward. The evidence is that he lost at least one business contract, if not more, and did tremendous damage to his name that we know of. And of course, as the court is aware, when you're talking about a campaign by Facebook, it's impossible to know who all this reached and what we only know of the people that posted that we were able to see. I'm never doing business with Hoffman. What about the ones that didn't post that and just didn't do business based on these statements? So I see I have a minute left. The damage was extensive. It almost killed him. I'll go on to say that the issues as far as punitive damage and attorney's fees, which weren't raised here, we will rely on our written submissions on those things. It is our respectful belief that if ever there was a case where a defendant did not care about the consequences of their actions and knowingly tried to hurt another party, this is such a case. Briefly, as to the issue on the court's authority to strike the pleadings and the counterclaims, both trial judges pleaded with Mr. Clark through 12 motions for sanctions to stop doing what he was doing. And Mr. Clark got online and said, I'll never stop what I'm doing. Put me in jail. He was in jail for 30 days during Christmas, missed Christmas with his family. He still didn't stop. He came out and he said, that was the best 30 days I ever spent for my business. He insulted the judges. He threatened to harm me. What he did was intentional. And the trial judges in my last 5 seconds said to him, I don't want to strike your pleadings. Please don't make me strike your pleadings. And he forced them to. This is a doing of his own choosing. Thank you.
Judge Greer, do you have any additional questions of Mr. Katz?
No, thank you.
Judge Schumacher, do you have any questions of Mr. Katz?
No, thank you.
We are ready for rebuttal arguments. Mr. Cease?
Thank you, Your Honor. May it please the court again. I just want to start just and briefly touch on the idea about the civil extortion damages. If the court were to look in the appendix, I believe it's Appendix 2, it might be Appendix 3, but page 240. In any event, it's the court's order regarding post-trial motions. There's specifically a section talking about civil extortion damages in that. And so as the court's aware, the main issue with error preservation is, was it raised and decided by the district court? It was absolutely decided by the district court in this case. And I just kind of want to go off of a little bit with what Judge Greer had asked Mr. Katz. The problem is that the testimony, and I think in even the argument of Mr. Katz just now, with all due respect, it's all about the defamatory comments. And the authority in Iowa and the literature, specifically Mr. McNulty's law review article, where it outlines the cases, the damages, the reputational damages cannot be based upon the defamatory comments themselves. And there was really only one customer that was presented evidence. And we touch on it in our brief, but I think it's important to discuss it now also. When you look at these libel type cases, there really are two sets of damages that you have to look at. There's the reputational damages, and those are those difficult to grasp damages where we're talking about an individual's reputation. And then there's the actual damages where we talk about lost profits, emotional distress, and things of that sort. And there just wasn't really any evidence about that can warrant and justify a $4.5 million verdict for Hoffman, for DIY, and $1 million for Hoffman. It just wasn't there, and it was all speculative. And when you look at the way the evidence actually came in, that was pretty evident, because during cross-examination, when he was pressed on how do you come up with these lost profits, it immediately just switched to, well, what's a person's reputation worth? And that can't be the basis. The defamatory comments can't be the basis for the award of damages. And that's specifically outlined. And what we're really asking is this court to really follow the precedent in Reese versus O'Malley, the case from the 90s, where there was an award of $250,000 that the Supreme Court said was excessive because the case was primarily tried on the defamatory comments alone. And that's what we're asking this court to do, is follow that precedent. And I just want to touch on briefly, we argue in our brief, as Mr. Katz suggested quite extensively, why we don't believe it was proper for the district court to strike the pleadings in the first place. The rules cited by the district court in striking those pleadings are those discovery rules. We question whether that's applicable in this type of situation. But even if we assume that it is, the purpose of those discovery rules is to move litigation along. And really the ultimate question is was another party's case hindered by the actions of the opposing party in such a way that it prevented the litigation or it prevented the individual from presenting their case. Well, I understand and I can appreciate Mr. Hoffman's position about what Mr. Clark was doing. None of those actions in any way hindered his ability to present his case. And that's why we think it was improper for the district court to strike all of those pleadings. It definitely probably would have affected the damages award based on those actions and continuing actions, and why things like punitive damages could have been requested, but it in no way hindered his ability to ultimately present his case. And
don't you have kind of a different situation here where you have this consent order that he violated over and over again and basically in many of these postings kind of slap the court in the face?
Sure, and I understand the need for those contempt actions and why they did those. May I finish just briefly?
You may.
Thank you. But to take that step, and if you look at those discovery cases that we mentioned, the main goal of our litigation and practices in America is so that we can have a trial on the merits. And does the discovery actions prohibit that trial on the merits? And those actions didn't prohibit the trial on the merits, and that's the problem. So for those reasons, we'd ask that this court reverse the district court.
Judge Greer, do you have any additional questions of Mr. Cease?
No, thank you.
Judge Schumacher, do you have any questions of Mr. Cease?
No, thank you.
The matter of Hoffman versus Clark is now submitted, and we will be adjourned. Thank you, Mr. Katz, Mr. Livingston, and Mr. Cease.
Thank you.
Hear he, hear he, hear he. The Honorable Iowa Court of Appeals is adjourned.